Everything I share today is for educational purposes only. This is not legal advice, and I am not your attorney. If you or someone you love has been a victim of police brutality or excessive force, contact a licensed civil rights attorney immediately. He was pulled over for a broken tail light. Routine stop. He followed every instruction. Hands visible, voice calm, no sudden movements. 30 seconds later, he was on the ground. 3 officers on top of him. He spent 4 days in the hospital. No charges were ever filed against him because he had done nothing wrong. But the officers who put him in the hospital, they went home that night, back to work the next week. No charges, no discipline, nothing. This happens in America every single day, and the question that millions of people are asking right now is not just, is this right? The question is, what does the law actually say? What rights do you have when a police officer uses force against you? And what legal tools exist to hold officers accountable? Today, I am going to answer those questions exactly the way I would sitting across from you as your attorney. The issue: police officers in America have the legal authority to use force in certain situations. That authority is real and it is necessary. But that authority has limits. When an officer crosses those limits, when the force used goes beyond what the situation legally justifies, it becomes excessive force. It becomes a violation of your constitutional rights, and it potentially becomes a crime. The legal question here is twofold. First, what standard does the law use to determine whether force was excessive? Second, what legal remedies exist for someone whose rights were violated? The law 3 legal frameworks are critical here. The Fourth Amendment protects against unreasonable seizures. Courts have held that the use of excessive force during an arrest or detention is an unreasonable seizure under the Fourth Amendment. This is the primary constitutional basis for excessive force claims. The 14th Amendment guarantees due process and equal protection. When excessive force is used in a way that shocks the conscience, particularly against people in custody who pose no threat, it can also constitute a due process violation under the 14th Amendment. 42 U.S.C. Section 1983, commonly called Section 1983, is the federal civil rights statute that allows individuals to sue state and local government officials, including police officers, for violations of their constitutional rights. This is the primary legal tool used in excessive force civil lawsuits. Now, the most important case you need to understand is Graham versus Connor, decided by the Supreme Court in 1989. This case established the legal standard that all excessive force claims are measured against. The court ruled that the reasonableness of force must be judged from the perspective of a reasonable officer on the scene, not with the benefit of hindsight. The standard is objective reasonableness. Courts must consider 3 specific factors: the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, and whether the suspect is actively resisting arrest or attempting to flee. This standard has been criticized heavily because it gives officers significant legal protection. What matters under Graham is not what actually happened, but what a reasonable officer in that situation might have believed was necessary. That is a high bar for plaintiffs to overcome. Then there is qualified immunity, one of the most controversial legal doctrines in American law. Qualified immunity protects government officials, including police officers, from civil liability unless their conduct violated a clearly established statutory or constitutional right that a reasonable person would have known about. In practice, this means that even when an officer clearly uses excessive force, They can escape civil liability if no prior court case has ruled that the exact same conduct in the exact same circumstances was unconstitutional. Courts have used qualified immunity to dismiss excessive force cases, even in egregious situations. It remains one of the biggest legal barriers to police accountability in America. Real-world application in 2020. The death of George Floyd under the knee of a Minneapolis police officer for 9 minutes and 29 seconds triggered the largest civil rights protests in American history. Derek Chauvin was convicted of murder and manslaughter, one of the rare cases where a police officer faced full criminal accountability for use of force. But Floyd's case also illustrates how exceptional that outcome was. The entire incident was captured on video from multiple angles. Multiple witnesses were present. The medical examiner ruled the death a homicide. Even with all of that evidence, the prosecution was not considered a guaranteed win. In cases without video evidence, without witnesses, without a medical examiner ruling of homicide, the legal outcomes are dramatically different. Officers are rarely charged criminally. Civil cases are frequently dismissed on qualified immunity grounds. Families are left with nothing. The legal system as currently structured makes accountability for excessive force genuinely difficult to achieve, even when the facts seem clear. Common mistakes. The first mistake is physically resisting during the encounter even when force is being used against you. I know how wrong this sounds, but physically resisting an officer, even an officer who is acting unlawfully, creates additional criminal charges against you and weakens your civil rights claim. Your fight must happen in court, not on the street. The second mistake is not seeking immediate medical attention. If you have been subjected to excessive force, go to a hospital or urgent care immediately, even if your injuries seem minor. Medical records documenting your injuries created immediately after the incident are some of the most powerful evidence in an excessive force case. The third mistake is not preserving video evidence immediately. If bystanders recorded the incident, get their contact information immediately. If there are surveillance cameras in the area, your attorney must act fast. Surveillance footage is often overwritten within days. File preservation demands immediately. The fourth mistake is giving detailed statements to investigators before speaking with an attorney. After an excessive force incident, you may be asked to give a statement to internal affairs or other investigators. Do not give detailed statements without first consulting a civil rights attorney. What you say can affect both any criminal case and your civil claim. The fifth mistake is assuming that filing a complaint with the police department is enough. Internal affairs investigations rarely result in meaningful discipline. A formal complaint creates a paper record, which is valuable, but it is not a substitute for pursuing legal remedies through a civil rights attorney and the federal court system. Your action step zone. During any encounter where force is being used, do not physically resist. Verbally state clearly and calmly, "I am not resisting." Keep repeating it. This protects you legally and establishes on any recording that you are not fighting back. 2. Seek medical attention immediately after any excessive force incident. Every injury documented, every treatment recorded, every diagnosis written down becomes evidence in your case. 3. Document everything as soon as you are safe. Write down the exact sequence of events, officer names and badge numbers if you were able to observe them, patrol car numbers, time and location, every word said. Do this before memory fades. 4. Contact a civil rights attorney immediately, not days later, immediately. Preservation of evidence, surveillance footage, witness statements, all of this has a time window. An attorney must act fast to protect your case. 5. File a formal complaint with the police department's Internal Affairs Division and your state's Attorney General Office. Also, file a complaint with the United States Department of Justice Civil Rights Division. These complaints create official records and, in patent cases, can trigger federal investigations into entire departments. The law gives police officers authority to use force when necessary. But that authority has constitutional limits. And when those limits are crossed, when a badge becomes a weapon used against the people it is supposed to protect, the law provides tools to fight back. Those tools are imperfect. Qualified immunity is a real barrier. Criminal accountability for officers is rare. But civil rights litigation, federal investigations, and public accountability have produced real change in departments across this country. Know your rights. Document everything and fight in court, not on the street. Share this with someone who needs to understand what the law actually says about police brutality. And for any real legal situation, always speak with a licensed civil rights attorney in your state immediately.